My name is Lauren Glynn, and I'm an attorney up here in Cooperstown, New York. While I am an attorney for the purposes of this talk, I'm not your attorney. Just please take this as an educational and informational discussion. And if you have any questions, make sure that you consult an attorney near you. Our talk is going to be on Wills and Trusts 101, and we will begin with what we will cover. So this talk is on Wills and Trusts 101. It's an introduction to estate planning. The goal of this talk is to give the people who watch it an idea of what they can do. It's not going to tell you what to do, but it does give you an idea of the risks and rewards of doing the estate planning. We are going to specifically cover determining whether or not somebody needs a will or a trust or something different. We're going to cover a grand overview of the estate process and what happens after you die with all of your stuff. What are the steps people have to take in order to move it around? We're going to cover some common estate planning strategies that we use. And these are really common strategies. You've probably heard of them and seen them in the Wall Street Journal, the AARP magazine, but they are strategies that, because they're so common, they're often misquoted or misused and misunderstood, just because it's something that people use generically. And it may be a thing that you've heard, but you don't really understand. So we're going to go over those. And then we're going to talk about some action steps that you can take to help minimize your estate and make the process easier. And then we're going to talk about how to hire an attorney, how to spot red flags on hiring an attorney, and what you're looking for when you look to hire an attorney in estate planning. So the first thing we want to cover is why we're here. It's not very often that I get to stand in front of people or a room and talk about what I do for a living, because what I do for a living is a very sad and painful subject, right? I help people when they're at their lowest point. They've either just lost a family member or they're contemplating not being here anymore. So it's not really something I can sit down in a coffee shop and have a chat, which makes me very excited about the idea of sitting in a room with a bunch of people to be able to specifically discuss this, because it is stuff that everybody should know. It's just stuff that polite conversation doesn't really allow us to go over. So one of the main reasons that I happen to gravitate towards estate planning and why I really like it and love it is because my family was greatly affected by it. I came from 3 generations of poor estate planning that basically watched generational wealth disappear. The first was didn't do a plan, didn't understand a plan. The second did a plan, but didn't understand the ramifications of it. And then the third, they didn't bother with the plan because why? Which resulted in a lot of pain for our family. I got to see all of the emotional reactions from my parents. I got to see it from aunts and siblings and uncles. And it's something that I don't really like. No 12-year-old should really know what these things are. And I feel like it's something that if I can help educate people about why it's important, I can save a bunch of pain for you and your family. Which leads me to why you are here, again, sitting in a room with me, talking about death and talking about planning for basically the transfer of your wealth and assets when you go. Sometimes people come in to see me because they already have bad news and they are looking for a plan to what do we do because they know that an end date is coming. Other times people are here just because they want to get a peace of mind. They're constantly worried. If you have young children and you ever go out on a date and leave your kids behind, it's a very fearful thing. I just experienced that one. What happens to them if I don't come home? Estate planning is something that can help you with that and give you a peace of mind before you leave, at least out on the date. But I understand that everybody sitting here probably has some pain point and some goal they want to accomplish. And I am hopeful that I can actually help you do that. And if we don't, I hope we can connect and I can help you later. So the first thing I do want to talk about, though, is because estate planning is something that is so painful for people, a lot of people don't end up getting estate plans. People still die. People in this county have been dying here since 1790 without wills. And they don't have estate plans. They've just died and we know what to do with their assets because there's a whole series of laws written on that. But in order to get people to actually come to terms with the idea that they're mortal, there's a lot of attorney marketing that goes into what estate plans are and what they should be doing. And a lot of that attorney marketing is really fear-based, and it's something that I think actually discourages people from coming in and getting their plan, because they're worried and afraid that they're going to come in and somehow be told that this is bad or that they can't be helped and that they're just destined and doomed to, a terrible experience either way. So I want to talk about what those myths and rumors are so that we can see them for what they are, which is just really sharp attorney marketing to get people to come in. There's a statistic that I need to look up. I think there's something like only 35% of Americans have a will and testament in place, which is not very many people. Like, it's not even half the population. That's very, very few people that have actually come in to get this planning done. But one of the myths that has gone around is everybody needs a will. Everybody has to have a will. You really need to avoid probate. That's a big one. Most people don't even know what probate is, but they all know it should be avoided. My other favorite one is if you die without a will, the state takes all of your assets. Also not true, but something that I've heard repeated many times. I've had two new ones this year though, so I put them on the sheet. I hadn't heard them before, but I did get them from new clients. One was that if you don't have a will, you have a special death tax. That does not exist. Death tax is not a thing, especially not in New York State. And there's no difference in the taxes you pay per se. I mean, depending on your plan. But special death tax for people without a will isn't real. And then the other one was if you die without a will, people won't know who can claim your body, so that you end up becoming a ward of the state and you get immediately cremated and buried in a mass grave with other paupers. That's also completely false. That was a really weird one that came in. It was a very specific situation, but there are laws that determine if you don't have a will, there's actually a specific statute that determines who can pick up your body from the morgue. We used to not even have those statutes, but after 9/11, New York State codified the actual order of go of what family members can come in and claim you. So there's no reason that not a nursing home, a funeral home couldn't release your body. So if you've heard of any others, I would open it up to have people tell me if they've heard of any other rumors, but those are all the myths and rumors that you have. So main question that I get is, as an estate planning attorney, is, do I need a will? And my answer to everybody is the old amazing lawyer answer of, it depends. Right? I don't know if you need a will. A lot of this is going to depend on what you own, what you owe, and where you want your stuff to go. So we're going to take a look at your specific situation. I have put together some handouts in your packet, and we're going to be referring to them as we go through. One of them is a worksheet. You also have a pen. So we'll have you fill out the worksheet when we get there, and that will help inform you as to whether you believe you should have a will. So the two questions as an attorney when I'm evaluating when a client comes in of whether or not they need a will or a trust or something different is whether their ultimate goal of distribution matches New York's intestacy laws. Do you agree with New York's administration rules? So if you are single and you want all your stuff to go to your biological children, that's going to be what happens if you have biological children that outlive you. If you are married and you have biological children and you want your spouse to inherit everything, that is not going to be what happens. In New York State, spouses only get 2/3 of your assets or $50,000, whichever is greater. So if you're making a plan thinking that your spouse is going to inherit everything automatically, that may not happen. And when that happens, when an administration like that happens and the kids get access to it, it can turn into a lot of hurt feelings and you can leave your spouse in some pretty hard financial straits. Especially if the kids go, well, what if your spouse gets remarried? I should take my inheritance now while I can. But it might leave mom in a lurch. Or the parent and the other parent in a lurch. So that's something that we have to figure out is what you want going to be what happens by law? If it's not, we have to do something. If it is, then we have to figure out if we have to do something. But if it's not, we definitely have to do something, be it a will, a trust, or something different. And then the next thing we talk about is whether or not the person is okay with the time and expense of probate and what that puts on their family. So a lot of times we talk about these things and we don't actually define them. I do want to have two words that we really talk about, because when you go to look it up on the internet and you go into Google and you type, what is New York probate? what shows up is a bunch of words that already presume you know the meaning of probate. The definition of it is, the court administration process probate, and like, okay, but what does it really mean? So probate is, very simply put, it's the court process that determines whether your will is actually valid. That's it. So if your will is a valid will in New York, there's rules to this. It has to have been witnessed by two people. They have to have signed the part of the will. You have to have published and declared your intent. You have to have initialed every page of the will. You do not need it notarized. And your witnesses have to be able to testify in front of the court that they saw you execute the will. So if you have witnesses that might predecease you, that's a problem. We want to make sure that when we're doing a will, we also have additional affidavits for those witnesses. So when the court is looking at a will that's being presented, someone's passed away and here's the will, they're going to go down this checklist, make sure it was executed correctly, that the person who executed it was in a frame of mind that could do so, and all of the other reasons. And if it's not, if something's missing, if one of the witnesses is also the executor, and it really looks like somebody got pressured into signing a will that they shouldn't have, the court's not going to allow that in at all. So your probate process stops right there. The second thing that the probate process does is it actually will make sure through filings and checkups with the executors that the wishes of the will are actually being followed, right? So we want to make sure that if we've given out specific beneficiaries and we've decided that we want to give money to these organizations, and we've decided that we want to leave the rest, residue, and remainder to these people, that those organizations actually get that money and those people actually get what's left, and that anybody in the meantime who got paid has an accounting to the court. So that's the process of probate in a nutshell. The process of administration, which means dying without a will, is the same, just without the will validity part. We just say, okay, who's the right person that should be, working on this estate, not who was named. Are you the right named person? It's just who's the right person, and then we apply intestacy rules instead of the will. So it's a little bit, it's the same but different. The next thing I want to talk about is the meaning of estate, because I think this is my favorite thing. When people Google the meaning of estate, the first thing that pops up is your net worth. Like, oh, an estate is your net worth, or an estate is a grand, luxurious property. And like, that doesn't help us. That's not actually what we're discussing. It makes no sense. So when we talk about an estate, I want to talk about it. I like to think of it like it's just a corporate fiction. It's the same thing as a business or an LLC. It's just a corporate fiction. It's a bubble that pops up after you die that contains all of your things. So because you have died and your social security number no longer works, none of the financial decisions being made are yours. It's not really a representative of you. But also because the people who administer it and actually manage it, your executor and your executrix or your administrator, because they aren't you, and it's not their stuff, it's not theirs either, right? They're just the managers. So it's like this own separate company that sits in and of itself. It's meant to be temporary. It's only going to be there long enough for the people in charge to actually dissolve it and give everything away that it should be given away. So that is, when we talk about the estate, that's really what we're discussing. We're not talking about, huge grand properties. We're just talking about what you own in its own separate little bubble. When we talk about the combination of those two terms, your probate estate, what we're talking about is everything that you own at the time that you die in your own name. So all of the stuff you leave behind that you haven't really given out in advance. The big ones on this is real property. If you have real property in your own name in New York State, you will have to file a probate proceeding if you don't do something else, and all you do is a will. If you have, and real property could be your house, it could be land, it could be an investment property. It's just anything physical, and it has to be filed in the county where the property is located, because that county has jurisdiction over its own lands. The other main ones that we don't really think about a lot, but are really important, are items like your cash accounts, all of your bank accounts that you do your daily transactions out of. So like your savings account, your checking account, any of your like, you know, your medium savings account, any of your financial buckets that you have, if you don't have beneficiaries listed on those accounts with our local banks, which is abnormal around here, right? Most people don't put beneficiaries on their checking account. If you die and you don't have beneficiaries, those funds get frozen. Those accounts are frozen, and that's a part of your probate estate. That can cause a lot of problems moving forward if your funds are frozen for all of your beneficiaries. Also, a common thing that people really love nowadays is what's known as your side hustle. Where we talk about your side hustle or your home hustle. People have small businesses, they work from home. That business, if it's a DBA or an LLC, is something that will get pulled into your estate, and the value of that business gets pulled into your probate estate. Anything that's physical and tangible, your clothing, your jewelry, your antique collection. Now, if you are a person that doesn't have a lot of fancy stuff, and it's just things that, hey, if I die, you're going to donate my clothing to charity, then we don't really worry about all those items. But if you have collector's items worth of things, if you have fancy paintings or other items in your home, like those are items that have to be declared in your probate estate, and that will drive up the value of your probate estate before they can be gifted away to where they need to go. And then the hardest one around here is actually cars. If you own more than one car in your own name, the DMV gives you some trouble. If you only have one car, you get one free title switch with the death certificate. So if your spouse passes away and they have a car, you can walk in with a death certificate and they'll give you a new title to your own name, no problem. But if you have a second fun car, which is common around here, people tend to have like winter cars and summer cars. So if you have two cars, you only get one title switch. And then other than that, you actually have to go to a court battle to figure out where the car is going to go. You got to go back to court for it. So, and it can be a small estate if the car is worth less than $50,000. Then we do a small estate, but it's still something that will drive up the value of your probate estate if you have cars. Things that don't count. So the good news is things that don't count are usually the biggest things we have. So life insurance policies do not count in your probate estate if you have beneficiaries named that are just not your estate. So, pro tip, never name your estate the beneficiary of life insurance. Don't do it. It brings it into your probate estate. It makes it taxable, but depending on the value of the insurance, you don't want to do that. You instead want to name either another entity or a different beneficiary outside of yourself for that money to pass. Basically, inheritance tax free and income tax and all the other fun asset taxes are free. Like life estate proceeds are really well protected by law as long as we don't give it to ourselves. And then brokerage accounts. A lot of brokerage accounts are really, really good when you set them up. They will do a wonderful job of making sure that you have named beneficiaries. Some brokerage accounts have rules against naming minor children, some don't. It really just depends, but whenever they give you the go-ahead and they open your account and they take your money, they're going to make you sign on the dotted line as to who the next owner is going to be. So those don't qualify. We want to know that we have those things because those are assets that we can use to fill in the gap of other parts of our planning, but they don't qualify for your probate value, so you don't have to add them in. I did give you a probate. So in the talk, I do have a probate worksheet where I have people write down the title of their asset as well as the value of their asset. You take a few minutes, we can go through, think about what you have, and you're going to put down in the value. We want to make sure we put down the fair market value of today. So it's not what you bought it for, and it's not what you owe on it, and it's not what your equity is in it. It's if you sold it today, what could you get for it? That's the value that you use for determining the value of the probate estate. The other numbers are important. The equity numbers and the debt numbers are important, but they aren't what's used to determine any of the expenses. It's kind of funny that when you look at estate expenses, they're valued based on the overall value of the estate. They're not valued based on your equity. It's how much the executor has to physically handle what the value of that is, how they get paid. So it's the grand value. So you're going to have to sit down and go through that. Once you have your grand value number, then we're going to take a look. And I would normally give them like 5 minutes to like actually write it down. And one of the things I would tell them too is, oh, and if you own joint property with your spouse, add it into your probate estate unless you never get into a car with your spouse. because a lot of people die together because they're together all the time. So if you spend a lot of time with your spouse and you guys travel together and go on trips together, put that in as a potential value, because if you die at the same time and you don't have plans and neither of you have it, then it goes through probate. But we understand that most of the time spouses don't die together. Though weirdly enough, we actually had, like 3 weeks ago, one of the more famous couples in our town actually died within 2 days of each other. They were both in their late 80s. Like the first one to go was unexpected and the second one just like gave up. It was crazy, but they were like the founders of one of the biggest businesses that we have locally. It's really kind of weird how stuff like that happens. Right? And they're beloved. They were like, everybody knew them as like Grandma Barb and Grandpa Charlie. And they were always at it's called the Fly Creek Cider Mill, where all they do is press cider, feed people apples and cookies, and like the kids go and throw corn at the ducks. So it's one of the things that locals absolutely love. And it's really a great spot, but these were the founders of it. And so it was just, the community was so upset about it, but it was weird that they died within like 2 days. So moving forward, how much does probate cost? Once we've determined how much the value of your assets are, then we can give you a pretty good estimation of what probate would cost if you died today. Understanding that all of these things change, but some things don't change. The first thing that doesn't change is court fees. So in the PDF that has all of the probate costs on it, there's a set that says court fees, and it'll give you a value based on the overall value of the estate, how much money you're going to pay to the court just for the court to see you. After that, there's a set schedule by the state of how much an executor gets paid. And that's something that the executor can always opt to not be paid, but we want to make sure that we understand that most of the times executors deserve to be paid, especially if we leave them a financial nightmare. Like they are usually underpaid for the amount of work they do based on this formula that's given to us by the state. The third thing is that attorney's fees are fairly predictable and reliable. A lot of attorneys like to use the same formulas, and we use the same formulas because we have experience in doing the estates, so we know roughly how much work is going to be involved. You'll also see that the other hidden cost is going to be time. If you go through probate, it takes a long time. You're going to have at least 9 months before anybody really gets money. And that's a long period of time to ask people to wait for their inheritance. And then the final thing is the carrying costs. If you have businesses and houses and property and pets, you know, or if you have, let's say you have a hobby farm, someone's got to pay for those goats and feed them. You know, somebody's got to make sure that the house stays insured so that nothing happens to it. And we don't always get access to the money immediately, as we'll show you later. So there's carrying costs that come with owning your assets that your executor either has to front or someone else in your family will have to front. So until we can even get access to your money, if you go the probate will route. So taking a look at that, I have a slide in here that does the math for you, but you can do the math on your own. I gave you all the schedules. So in $100,000 estate, you're looking at court fees of about $420. You're looking at an executor fee of $5,000. It's 5% of the first 100,000. Because it's $100,000 estate, it's probably not real property. You probably just have bank accounts and maybe a car. So your attorney's fees might be a little bit lower than what I've said here. I've put in $3,500, but you could probably negotiate an attorney fee down to maybe $2,500. That's the minimum most attorneys will take for probate, just because of all the paperwork. And the paperwork that's involved doesn't change based on how many assets you have. I still have to file the same number of papers. I have to file the petition. I have to file your inventory. I have to file all the accountings. I have to file the receipts and releases. I have to file all of the citations. So all of that stuff is still the same. So the minimum number that an attorney will usually take is 25. Just if we know it's simple and there's only one beneficiary and it's, you know, 100,000, then that would be an okay cost. So on $100,000, you are looking at around $8,000 of fees to go through probate, which is probably the most you'll ever pay to avoid probate. So that's kind of a good deal with $100,000 or less. But as you move up in value, you'll see that all of these expenses correspondingly, percentage-wise, they get smaller, but actual number-wise get significantly larger to a point where people think it's a ripoff, which I understand. But if we look at a $500,000 estate, a $500,000 estate is usually around here somebody that has a couple of bank accounts and a house and a car. right? That makes it 500 pretty fast. You've got a house that's got a 350 value on it. You've got, you know, 2 bank accounts at, you know, 50 to 70. Maybe one is your midterm savings. Maybe one is your checking. And then you maybe have a car that's got, you know, 25 to 30,000 in it. So you reach that 500,000 mark. And once you reach it, you're paying the max amount of court fees, $1,250. Okay. Woo, really expensive. But your executor fees go up, and they're going to go up to about $19,000, which is a lot of money if you don't have that much stuff that's making up that number. So if you have the 500 just because you have one really nice house, that's a lot of money to pay to have a person move one piece of property. You know, if you hit that number because you have 17 drip stocks in CompuShare, like that's a nightmare for me. So you're going to pay the $19,000 because that's a nightmare for an executor to sit down and have to actually go through all of these original stock. You know, some people own original stock certificates still, like instead of having things inside a stock brokerage account, they actually have the physical paper stocks. Those are nightmares to track down, absolute nightmares. But I get a lot of them. So in general, when an attorney is quoting you an estate, they're going to look at what the estate's made of. They're going to look at the amount of work they think they're going to have. They're also going to look at what they think the beneficiaries are going to do, if they're going to be pleasant or if they're going to fight. So it is normal for an estate attorney, because we also never know when an estate is going to close, and attorneys do not get paid until estates close. They're going to look at the overall time frame. So if an attorney offers you a deal where they say, I'm going to take a set percentage and you can communicate with me as much as you want, and it doesn't matter how long it takes, I'm only going to get paid this amount. And normally what they will offer is the executor's fees minus 20%. Take it. I have never seen an estate where people made out on an hourly bill versus a flat fee percentage. Normally people think that the flat fee percentage is the attorney trying to trick you. It's really the attorney trying to get out of keeping hourly records. Like, I don't want to have to charge you every time there's a 5-minute phone call. I just don't want to have to do that work. So I'll do a percentage base. But what it inadvertently does is it encourages your executor to call you a lot, which is fabulous as an attorney. I would rather people call me and ask me the questions so that I can answer the questions, rather than them not calling me because they're afraid of being charged an extra $50 to $200 depending on the question. So they don't call, and then they don't know what to do. So then they make a decision that at the end of the day turns out to be wrong, and it costs the estate more money. So that's like a thing that we want to make sure we don't do. So usually percentage fees are a really good deal for executors, even though people look at that and they go, oh my God, that's a lot of money. But again, it all depends on the makeup of the assets. But you need to know that, so that, you know, what are they actually basing it on, so that when an attorney sits across from you and someone says, oh, I can do it I'll do the entire probate for $2,500. They're probably never going to talk to the executor. They're probably not going to help them with anything. They're, you know, make sure that, you know, this is an indicator of what attorneys are really looking to do. And then I just put in the example of $1 million estate. So if you are one of those people that you have that kind of cash and you have those types of assets and you don't take care of it, you are going to pay a lot of money. You're going to pay the $1,250 in the court fee, but then you're going to be paying basically minimum wage for a year for someone to administer your assets for a year. And then you're going to be paying the attorney a really big chunk of change, you know, $27,000 for one estate, depending on what makes up those assets. That's a lot of cash for them, which makes your professional fees on $1 million estate somewhere around $60,000 to $70,000. And so it's funny because New York State thinks this is appropriate, because if you look, I put in the percentages. So New York State says, oh yeah, it's on $1 million. It's only a little over 6%. But normal people look at it and they go, but it's $60,000. Like, that's money that could have gone to my kids. $60,000 pays for a year of college for my grandkids, right? But it's just a little over 6%. So it's something that is acceptable by the state, but mind-blowing for the rest of us that look at it. The last cost that we got to look at is the time frames. So I did give you guys in your folders, I did give you an administration time frame that shows you exactly the documents that are needed, how long it takes between each of the steps. If an estate is run really well and you have people that give you their signatures on time, they know where to find a notary, you know exactly where the will is located, you still will take 9 months. It'll take you at least 4 to 6 weeks to get in front of a judge. If you have all the papers lined up perfectly in front of the judge, then the judge is going to admit everything immediately and be fine with it, but it still takes a while to get there. Once letters are issued, once an executor is named and declared and letters are issued, it starts the clock for creditors to step up. And that's a 7-month time frame. And during those 7 months, your executor is at risk. And I say that because a lot of times, once we get letters is when executors are able to finally move money. So it might be that they've only spent 4 to 6 weeks of trying to jerry-rig your assets and your bills, but they really can only get access after that. Once they get access, they will have been yelled at for the previous 6 weeks by creditors, by beneficiaries. They're going to be really tempted to take those assets and distribute them. But all creditors have a 7-month timeline to get into court and to say the decedent owed me money. And if your executor gives away the money before all the creditors step up, they are at personal risk of having to pay the creditor themselves. So it is a liability to them as a person if they give the money to the kids immediately, and then there's a bill that none of us knew about that shows up from the hospital. And usually hospital and medical bills take 4 to 5 months to even be issued after insurance looks at them. So we aren't going to necessarily know whether the estate is even solvent for 5 months after letters have been issued. So that's something you really want to keep in mind, that we may not be able to give money to the kids. We won't necessarily get money to really put stuff into the house until we know what is the list of creditors. And I will say one of the worst ones I ever got was 6 months in, I got a life alert creditor, $200,000, because this person had to be put in a helicopter to be taken to the hospital where they died. 200 grand, 5 months in. So if we had actually given out the money before that bill hit, huge problem, like huge problem. So that's something that's a little bit crazy. So your monthly bills are still due though. You still have to pay your insurance. So someone's got to float this. And then the creditors are going to come calling. Credit cards are the worst. They call first, they call hardest. And they're the ones that make deals and offers. They'll try to tell your kids that you'll ruin, their credit score will be ruined. I think that was one of my favorites. I got your credit score will be ruined if you don't pay us. And by the way, we'll give you a 40% off discount. Credit cards do that because they know that in the statutory order, they are the lowest on the list to be paid. They are the people that get paid last of all creditors. So if they think it's an insolvent estate, it makes sense for them to try to cut a deal with an executor to get cash now, so that way they don't have to file in the court and wait their turn in line. So first thing we try to tell people to do is don't pay anything. So that's one of our big policies, pay nothing. But you, as the person that is making the plan, you can actually help your executor with this. You know how we talked earlier about your life insurance? This is a really good way because life insurance pays out within 3 weeks. As soon as I can send in a life insurance, as soon as I get your death certificate and I send it into the life insurance company, they will just pay the money out. And so it's a way that you can get money and funds to your family and to your executor quickly. And so they can actually cover any of the expenses that are needed on a family property that they want to keep, even if the wolves are at the door for everything else. Same thing with a brokerage account. Once you give them a death certificate, they will transfer those assets immediately. They transfer them really quickly because the longer they hold the assets, especially in a stock account, if the market goes down, they are liable for the date of death value of that account. So if your father died on a Monday and that stock drops down, they have to pay you the equivalent of Monday's value, even if their stock's worth less. So they're going to be shuttling you right out. They pay you immediately and quickly. It's really a good deal. So we can set up those types of accounts to be a strategy effectively to help your executor, to help your family tide it over until we can get your estate moving forward. So do you need a will? To circle back to the question, again, it depends. If you look at these numbers and you say, hey, I'm not happy with these numbers. This is absolutely crazy. I couldn't in good conscience do that to my family. I'm not spending $60,000 on this. Then yeah, we need to talk. You need a trust or something different. A will is going to still subject you to this. But if you look at this and you say, hey, $8,000, I don't have that much stuff. It's really easy for me to shift some things to my spouse. We all have these stuff. It's not so bad. Then maybe a will is all you need, if that. Maybe the administration, intestacy rules is fine for you. So it's really an individualized look, but those are the two factors we want to make sure that we can tell before we move on. So if we've decided that we're unhappy either with the administration rules and we're unhappy with the expense of probate, we're going to move on to some common estate plans, things that we do to make your probate estate smaller so that those expenses go away. And that's really the value of the estate planning. So 3 common estate plans that we have here in New York. The first one is called a life estate deed. You probably have heard about this before. A lot of people get it incorrect. It's a pretty popular plan. The next one is called a revocable living trust. Those are also things that people are often told to get, and yet they don't really understand what they mean. And then the third is an irrevocable trust. So those are pretty famous too. But starting with your life estate deed. When you look at a life estate, what you have to understand is that ownership is divided by time, especially in assets. When I own an item, I own it until I either give it up or until I die, right? So I own it for the period of life that I am breathing, and that's it. I can't own it after I die. So a life estate deed takes that concept and it puts into the physical deed to real property that on the expiration of this person, the life estate owner, the property will immediately transfer invest into what we call the remainderment. It's a way for us to say, I own all of today, but the next person in line will own all of tomorrow. So it's a good way for us to really divide that ownership, and it has a lot of positive qualities. It completely avoids probate. It allows me to transfer property without needing permission of the judge, because I don't have to show anything except that the life estate owner's expired and the other person can walk right into the property and it's theirs. During the time the life estate owner is living, they are responsible for the maintenance of the home. They're responsible for the taxes of the home. They don't necessarily have to live there. It is not something that they own it for as long as they breathe, but it doesn't need to be their residence. So they can still go to Florida and rent it out in the winter, or they can, Airbnb the property. You can do a whole bunch of stuff with it, and they keep all the income and revenue from it in the meantime. So it's a good deal for the guy who owns it today. He gets all the benefit of today, and he could do anything he really wants with it. The remainderman gets the immediate transfer into them. So for them, it's easy, I'll just step right in and take it over. Now, you can only sell or transfer the property or put a lien on it. So if you need a mortgage or a HELOC for any reason, you won't be able to get one on a property that has a life estate deed unless all members on the deed qualify for it. So it is a thing where if you do this and you separate the ownership in that time frame period, your any creditor and any transfer of the property afterward requires signatures from all of the parties. Not that you can't, just that you have to have everyone agree. So if you have a remainderman that will never agree, not really a great plan, right? You will never be able to opt out of that property. The only thing you could do is opt out of your life estate early and actually deed your life estate back to the remainderman for money. So that's one way to close it out if you can't sell the property for value. There are some negatives to this. There are a bunch of downsides, and a lot of it, people think life estate deeds are really good to do if you have a blended family. Let's say you're the second spouse and you want the second spouse to stay in the house for as long as they need to and to use it and for it to immediately go to the kids. Well, the person that's only using it for their lifetime has very little incentive to spend any money on updates or maintenance. And if they know they're going to be dying soon, they have very little reason to pay the taxes. So there's a lot that goes into that, where if you don't want to put a contentious family relationship in this type of a deed, because it is really hard to unwind and because it is easy to abuse. but it is an option. So it is something that will remove your property from the estate. And for some families, it's the perfect option. Our next step up to get property out of your probate estate is what's known as a trust. When we think of trusts, I think everybody really thinks about what is the old college movie Animal House, with all of the like preppy guys that are there on trust funds and, you know, oh, I'm the trust fund baby. So we all have this impression that trusts are really only for the rich, wealthy spendthrift people. That's not what trusts are at all. Trusts are incredible, flexible documents that if you know and understand how to use them, they can really work miracles for families. So first, most basic though, when I say the word trust, I want you to have one picture. And the picture I want you to think of is just of an empty box. That's all a trust is. It's an empty box. And it's created by a person known as a grantor. So there are three people involved in a trust. There's your grantor, it's the person who created it. They're the ones who create the rules and design the box. They're the ones that design what can go in and come out. And they write the paper, you know, well, the attorney writes the paper, but the grantor tells us what they want the paper to say in terms of what comes in and what comes out and to whom it all goes to. The trustee is the person who's ultimately in charge of what comes in and goes out and is in charge of enforcing the rules the grantor has written. So that's their only role. And the last person is the beneficiary, and that's whoever has entitled to anything coming out of the box. So those are the three main rules, and that's basically just an empty box. And how we create the rules is what makes those boxes have special meanings. So our first special box is a revocable living trust, and it's incredibly special because in this type of a trust, the grantor, the trustee, and the beneficiary are the exact same person. When we combine the three roles into one human, we basically create a portation, like a portable device that I can fund things into. We can put property in there, we can put jewelry, money, bank accounts. But because I wrote it and I get to be the person who decides what comes in and out of it, and I'm the only beneficiary of it, it's effectively still mine. Right? So while I put all my things inside this box, the box still belongs to me and I maintain absolute authority and control over it. So what that does is it means I don't have any other tax obligations because it's still mine. I still own it. The box stays this way. I have complete authority over my assets. I can take stuff in and out of it however I want. I don't need anyone else to sign on the dotted line. It's mine. But if I die, if something happens to me where I have this box, the box immediately closes and whoever I've named as my successors can take it. And they don't have to go to court and they don't have to go to probate. They just pick up my box and walk away with it because everything that matters to me is all, or everything of value is already titled into that box. So it's effectively this really cool transport device that lets us just transfer wealth from one person to another without needing to have any of this court stuff. One of my favorite things about it is that it's absolutely private and it's always flexible and it can change. Until you die, you can constantly change the terms of your trust. So you can revoke it, you can rewrite it, you can revoke it, you can amend it, you can change who you want to be the ultimate beneficiary, you can change who you want to have be the successor trustee. It's a flexible document that can move with you through your lifetime if you care enough to actually pay attention to it. So many people think that once we set the trust up and we set it together, that it's completely set in stone and you can't amend or change or alter any of it. And then they forget they even have it and they don't even fund it. And then they spend a lot of money on a document that they've never used. Because why should I use it anymore? I don't want that person to get my stuff, or I don't like that successor trustee. They don't realize we can actually edit it and change it and make it different. So the cool thing I like about it is it acts like a handbag. I call it a handbag to help people with the picture, where I literally keep it on my shoulder. I can put everything that matters into it. And then when I'm done with it, I just pass it off to the next person and all my stuff is tucked away nicely into it. The negative to it, because it's my handbag and it's on my shoulder, other people can reach into it as well. Just like a handbag, I can get robbed. Someone could knock me down and take it away. And that is a thing about this type of trust, that it's really purely invented for estate planning. It's not invented for any type of protective purposes. So if you're at a place where you think that creditors are at the door, or you want to make sure that your spouse doesn't get tricked, this is not necessarily the trust for you. But this is a wonderful, flexible tool that will help people be able to transfer property without court intervention, and keeps everything private. I don't know if I mentioned it before, but all wills are published publicly. You can actually find every single will in our county online at websurrogates, .ny.com. I think it's .ny.courts.gov. It's the actual URL. But every will is public. So if you go back and you take a look and you want to see who, you want to be a nosy person and find out who got disinherited, you can. And so sometimes you don't really want that. And this will allow you to transfer assets completely privately. Nobody can tell you what to do with it, and no one will ever know. So if you don't want, nosy neighbor sticking their head in your business, trusts are a good way to go. The other trust that we're going to talk about, the third way of doing things, is called an irrevocable trust. And an irrevocable trust is what happens when the grantor and the trustee are not the same person. The trustee also could be a beneficiary, but usually the grantor remains the beneficiary, and the trustee will become a beneficiary when the grantor is passed. So that's usually when we do parent-children. But at the time the grantor is living, if there's an independent trustee, if there's another mind or another person, there's another gateway to say, no, you can't have your stuff back, that makes the trust a complete and separate entity from yourself. So when you put your items in the box, if you then close the lid of the box and hand it to someone else, and you have to say, pretty please, can I have my stuff back? You get a lot of interesting benefits from the government. So if you don't own that stuff, and that stuff is owned by your trust and managed by your trustee, anyone who comes after you personally can't take it because it doesn't belong to you anymore. Your trustee is actually responsible for getting your trust its own employer identification number. It can have its own employees. It's its own social security number. You can actually have your trustee, your trustee will have to pay its taxes. So the trust will generate, if you put any income asset, any income generating asset inside it. So like, let's say you put a rental property inside it, or you put, an account in there and a stock account in there that gets revenue, and it gets income, it has to pay taxes, like income taxes, like a person or another company. But it pays so the only negative to it is it will pay its own income taxes at the highest tax bracket that the United States Treasury requires. So it's not like it gets tax benefits like individuals do, because it is an entity and not a human. But sometimes it's a really small price to pay for the massive benefit of it not belonging to you. A lot of times these trusts are used for some very specific purposes. Supplemental needs trusts are one of the first types of this that I like to think of. A supplemental needs trust is a trust that's created by a third party, could be a parent or a grandparent, where a separate trustee runs the trust for the benefit of a disabled individual. So that disabled individual gets the benefit of money and doesn't have to pay the state for what the state pays for their care. So if you have a person in your family that is, how do I say this? If you have a person that's receiving benefits from the state, and they're, they could be part of Springbrook, they could be a part of Pathfinder. Those are all local locations for us for people with special needs and Down syndrome. But if they have their medical needs or their home care being paid for by the state, this is a way to keep them having assets and having stuff without the state reaching in and taking it back. Because if you're an individual with means, the state will take that from you to pay for your own care. They don't, there's a spend down test for it. So if you're a parent and your kids are going that direction and you want to set this up, it's a really good thing to do for them. And I've seen it pay for some really wonderful things for people that normally wouldn't have the opportunity. It's allowed children to go on vacations they wouldn't normally get. It's allowed kids to get prom dresses that they wouldn't normally be allowed to have. It's allowed them to have, anything above just the standard, maintenance and shelter that the government gives you. It can help them with extra and above medical care in certain circumstances. So it's really important. That's one of the best uses of this type of trust. The other thing we do is called the Medicaid Asset Protection Trust. And that's when we do these trusts with the main goal of separating the assets from ourselves outside of the Medicaid spend down period, so that when one of the people go into the nursing home and Medicaid looks at us, we can qualify income wise to make it, because all of my money producing assets are in another box and don't belong to me. And that is another interesting way we can do those things. It may become irrelevant in the next 5 to 10 years, because the governor is currently looking at a bill on her desk about whether or not Medicaid and nursing home care should be going in the direction of Massachusetts, where it's free for all, and where actual medical care should be affordable and accessible to everybody. So I am hopeful that this use of this particular use of this kind of device will eventually go the way of the dinosaurs. But for now, she hasn't signed that bill. It's been sitting there for about 9 months and it has not been signed. And if it does get signed, there is going to be a sunset provision in it, where it won't even take effect for another 10 to 15 years. So it may be of help for younger people, but it's not going to be something necessarily that will help people in immediate straits. The other type of irrevocable trust that we like to think about is, again, the spendthrift trust. One of the things we want to think about in the coming years is that the baby boomer generation was one of the wealthiest generations in America, and they are one of the largest generations in America, and they hold the majority of America's wealth. They're getting old. Sorry, I hate to be offensive about it, but they're getting old, and whether they like it or not, that wealth is going to transfer to 3 other generations, and the 3 generations are Gen Xers, millennials, and I think Gen Z. And these generations are generations that, Gen X is pretty decent. Like they don't have a lot of bad financial habits, but millennials have grown up in nothing but turmoil and disaster, right? Yeah. These are the people that ever since September, they remember September 2011 and nothing got better, right? September 11, 2001, nothing got better after that. Like we went into war and nothing good happened. College education is incredibly overpriced. We've had, stock market drop after stock market drop. We've had people just get fired. We've lived through a pandemic. So you're looking at a generation that's not used to handling money, at least not in the ways that the boomers are. Right. So it's very, very different. And when you have people that aren't used to handling this type of wealth that's going to come their way, they're susceptible. Right. They're susceptible to being tricked and parted with their money in many different ways, whether it's through the, oh my God, why are they having so many avocado toast Starbucks runs, that people like to say, but also through the, hey, to show success, you need to have a Range Rover, Land Rover, huge house. We're living in a generation now where debt leveraging is the norm for people to be able to show that they have a lifestyle, that they are successful. And that's really scary to think that all of this wealth that the generation above us has managed to compile, when it comes here, is going to be in the hand of financial newbies. And it could be that they find financial advisors that aren't really the best for them, or it could be that they do. But you want to make sure that if you're giving things into a trust and you've been able to put that money there, when that transfer comes down to the kids, it's going to come with instructions. And those instructions have to be followed. And it could be that you put time limits on it, that the kids can't get distributions until they're 30. It could be that you put income limits on it, that the kids can't get distributions unless they have more or less than X amount of money. There are some things you can't put in there, like you can't, public policy wise, you can't not allow somebody to have it or force someone to marry into a certain religion. Things like that can't happen. But you can actually give them a lot of structure and instruction by doing this. So that's something that an irrevocable trust is incredibly beneficial and helpful, and things that we really want to be talking about as a culture, because this is going to happen relatively quickly. The boomers are now in their 70s. This is going to be in the next 10 years. All of this wealth is going to transfer, and it's either going to come into the pockets of the people that really need it to dig themselves out of student loan debt, or it's going to come into our pockets and go back to the government in the form of the student loan debt, right? If you don't want it to go immediately to the creditors on your kids, you can put it in a trust and it can go to them directly to pay for other things, but not those creditors. So it's a huge gift to that generation if you can do that package and do that package well. The only other thing I really love irrevocable trust, well, not the only, but one of the other things I love irrevocable trust for is when we talk about pet trusts. So this is like a weird little niche, but a lot of people have pets around here and a lot of people have farm animals and big animals that are expensive to take care of. And you can actually set up a trust for the lifetime of an animal. An animal is property in New York State. It is considered to be, like if you have a dog, it's the value of a used dog. It's whatever you would get a used dog on the market for. So I've got a lovely old corgi. If anything happened to him, like he's a little piece of property, but he's my heart. But if something happened to me before something happened to him, I would want to provide and take care of him. And because he's a nice, old, lovely dog, he is on so many meds. I think that he's like $200 a month in drugs, which, he's worth it. He's worth it and he's still happy and life is good. But that's actually really cheap because on the flip side, I also have 2 horses and the horses I have are about $700 a month. So if something happens to me, those animals, and one of them is really old. I love her. She's 25. She's worth nothing, but she's a huge liability. So if something happens to me, my poor husband will have to figure out how to take care of and what to do with them. So I can actually set up a trust for the care of those animals and have him or someone else, because if he goes with me, someone else will have to manage this, so that my children can keep their beloved pets and my pets can stay living and happy and healthy where they are. And that's something that's to me is a really big deal. It might be to you too, but that's something that an irrevocable trust for the benefit of a pet can do. I'm actually doing a talk on October 30th at the animal shelter, in the Susquehanna SPCA, at, I think it's 11 a.m. To talk exclusively about how to take care of pets so that pets and kids aren't parted at your passing and things like that. So that should be fun. If you want to go to that talk, it'll be a little different. So again, main benefit, this type of trust is a safe. Once you put your money in it, it's there and it stays there and it's a good thing. So that's something that I really feel very strongly that people should consider once they get to that stage. So when you are hiring an estate planning attorney, there are some green flags, things that you should look for. And then there are red flags, things that should warn you against hiring this person. I will go over the green flags first, the things that say, go ahead. First, if the interview with the attorney is thorough. A lot of us meet strangers and we don't really want to share our personal information, but the estate planning attorney has to ask you these questions so that they can give you a comprehensive plan. They're going to ask you things like how many assets you have, what's your relationship like with your family, who your entire family is, what your health is. And if you don't feel comfortable and confident in telling the attorney the answers, they're not going to be able to plan an actual design path for you. You're going to not be giving them enough information that they need. But it is kind of a red flag if you don't feel like they are interested or paying attention, or you don't feel comfortable in giving them that information. Next, you want to make sure that when you talk to the attorney, that the explanation of the plan they're presenting to you for what they think should work, if that's a clear explanation and whether the benefit of that plan can actually be demonstrated. If they just say to you, you need a trust, they don't tell you which one or how much or what it's going to save you, then that's a red flag. You may want to ask them more questions and see if they can actually articulate to you why this is your best idea. Next, you want the estate planning attorney to be the type of attorney that encourages you to return. You want the estate planning attorney to be the one that says to you, we need to have a relationship. I'm not going to disappear. I want you to come back in every year or every couple of years as your life changes so that we can grow together and make sure that the plan matches you at every step of your life. For whenever death happens, you want to make sure the plan's updated. Last, a big green flag is if an attorney has a prepared pricing sheet. The reason I say that is a lot of times you might get nervous telling an attorney your entire life story, all of your assets, how much you're worth, and then you feel like the attorney gives you a price that's probably based more on what you have rather than what they're going to provide to you or what they require for their services. If they show you a prepared pricing sheet in advance, that means that they're not looking to take advantage of you. They just know that this is what their services are beneficial for you for. Now, some red flags. If the interview is rushed and not thorough, if you sit down with the attorney and 20 minutes later, they're like, okay, I have enough. This is all you need. Skedaddle. that's something that you'd have to worry about. They may not be actually having your best interests at mind or even open to the idea of your plan being anything other than a plain will. Next, if they can't explain the benefit of the plan, or if the plan to you is unclear, it's not your fault if the attorney cannot explain why this is the right plan for you. A lot of times clients feel that if the attorney tells them they have to do X, Y, and Z, but they don't understand, that somehow they're the one that's lacking. It's the attorney's job to be able to take the law and make it understandable to you. It's not your job to have the educational level of an attorney so that they can actually communicate with you what they mean. So if this is something where they make you feel like they're talking over you or not listening to you or not on your level, that's a problem with them, not with you. And that should give you pause before you hire them. Also, if the attorney displays a one and done attitude, if they say to you, this is all you're ever going to need, we're going to get this done, I'll take your file, put it here, and we'll never talk about it again, that means they're not really willing to actually work with you in the future and make sure that the plan is updated. That's something to me that would give me pause if I was looking at an estate planning attorney, because I know my life is going to hopefully seriously change and it needs to be updated as I move forward. Also, if there's no pricing sheet or if the prices are suspiciously cheap, that's something to me that if an attorney is undercharging what their services are worth, it's really hard for me to believe that they actually understand what the services are worth. If they tell you they can create an irrevocable trust for you that's going to protect your $1 million asset and they are only going to charge you $1,000, that's not a deal. That's an attorney that doesn't understand the type of liability they're taking on to be able to help. You're not getting priced out of the market, but you also don't want an attorney that is the bottom of the barrel or racing to the bottom. And a pricing sheet is really the best way for an attorney to demonstrate that they understand that concept as well. So like I said earlier, you want to make sure that the attorney has their prices in advance, that they can actually tell you and show you what the benefit of the plan is. And then you won't feel, even if, you won't feel like you're being taken advantage of. You'll feel like you're all on an even playing level, that you understand what it is you're purchasing. Now, that being said, before you even get to see an estate planning attorney, I have a few helpful tips for you. Some action steps that you can take today that are, most of these are completely free. You can do them without a lawyer, and it will seriously help your loved ones. The first one is to add beneficiaries to all of your bank accounts. And I mean all of your bank accounts, not just your big IRA or your investment account or your large savings account. Even the one that you only have $13 in because you opened it in college and you're never getting back to it type of an account. All of your accounts should have a beneficiary on it. Those are called transfer on death, payable on death, or taught in trusts. The three words all mean the same thing. And what it will do is allow the banks to give your money to whoever the beneficiary is and close out that account without having to go through probate. You also want to make sure that you double check your beneficiaries on your insurance, your life insurance, and on any of your brokerage accounts. You may have put them on when you first opened, but very few of us actually revisit our beneficiaries. It could be that we have different beneficiaries now based on when we open the account. You also want to get your finances together and organize them. This is something that financial planners and attorneys tell us to do all the time, but it really is helpful if we have one location that we can look at and say, this is a picture of what you have. Now, we need to know in particular where all your money is. What banks do you actually use? I usually start with clients by saying, where's your daily spender? If you were going to go buy lunch, what would be the account that you pay for that out of? Then where's your middle bucket? Where is your emergency fund? Where is your savings account? The one that if you're going to save up for a new roof or save up for something in the future, where is that account located? Then where are your retirement accounts located? You want to have the actual bank. You don't necessarily need the accounts, but you need to have the actual bank and what type of accounts we're looking for, somewhere that we can find them. We also need the same type of a thing for the company that holds your life insurance policy. Where are we going? Even if I don't know the policy number, if I know what company to talk to, that's going to actually be a lot less stressful for your loved ones than us just going, I know he had insurance, but I don't know where it is. And the final thing we need is just a sheet of your monthly bills. So I don't need your bank account to be perfectly balanced. I don't need anything else, but I do need to know what your monthly bills are. Because if one of your bank accounts is where your mortgage payment gets drawn from monthly, when you die, that account's going to be closed. And I need to know who to pay for your mortgage. And a lot of times our mortgages are bought and sold. That one in particular is really important. You may not have the same lender that you signed on with. And I can't necessarily go and find the recording of who it was all sold to as easily or as quickly as if you had just simply written it down. So making that a priority so that your loved ones can easily find it if something happens to you is very important. Also, you're going to want to update your healthcare proxy with your doctor or your local hospital system. This is something that nearly every hospital offers to you when you come through the door. And you say to them, I need to have a healthcare proxy in case something happens to me. In upstate New York, they will bring in a doctor, a couple witnesses, and a notary to sit and have you sign it in front of them. They want to make sure that this is done. They're on the same page as you. However, if you don't have it done and you want to go to an attorney, you can do it then. Also, you want to register to be an organ donor. A lot of times we do this when we're going for our licenses, but if you really do wish to be an organ donor, you can register independently online and just sit and go, this is what I would like. Now, if you're thinking of donating your body to science, which is another program that you'd have to sign up for in advance, you cannot be an organ donor because they're going to require your entire body to test. So you'll have to make a decision which direction you would like to go. Now, the other things we need to make sure that we set aside, and please do not put them in a safe deposit box. It's very difficult for us to get into those after you've died, is any type of legal document that shows your marital status, your divorce, or your separation status. Anything that shows the adoption of a child or the death of a loved one. You want to keep all of that together, what proves your family tree, in one folder where we can find it. Because one of the hardest things for me to do is to get your divorce decree after you've passed away. I need it to be able to get letters for probate, but until I have letters, I can't request it from the county where it's filed. So I end up in this very difficult spot. It's just easier if you have it already. And if you've gotten your divorce, but you don't have the decree, go to the county where it was done, request a copy, and just put it in your folder. That way your loved ones will have it to be able to move on. Also, keep copies of your most recent tax returns easily accessible. Your tax returns have a wealth of information on it for your loved ones. First, they'll know that you are up to date on your taxes and they don't have to worry about filing for you for previous years. But also it'll show them where all of your income comes from. And if your income comes from assets that they're not aware of, for example, you hold a note on a mortgage to a piece of property you sold, and so you're getting income from that, this is a way for them to find it if they can't see it any other place. Now, one of the least fun things to do, I think, is the last thing I'm going to tell you to do. And it's pretty much free. Go shop for your funeral. You're going to want to go to your local funeral parlor, wherever it is, and talk to them about your wishes. Funeral directors are really happy to put together folders for you, show you what the options are, and you can make the decision of what type of casket you want, whether you want to be cremated, whether you want to have certain music playing, whether you want a wake, whether you don't. And that's going to be very important, because if you don't pick out exactly what you want, your children will have to pick it out for you. And I promise you, your children are going to spend more money on you than you want them to. They're going to be feeling sad. They're going to be missing you. And they're probably going to say, well, mom deserves better. Mom was a wonderful mom and she deserves better. And so they'll take a look at the type of caskets, and maybe you just wanted a low grade casket, one of the cardboard guys that doesn't, biodegrades and is perfectly cheap, but they'll see a really nice casket that will look beautiful in the funeral parlor. That's your favorite color, blue. They might buy that one simply because it's your favorite color, and that may not be the choice you would have made, understanding that you're simply going to be buried in this box. But for them, it's a more emotional choice than it will be for you. So I recommend that you go in advance and actually sit down, understand what it is, understand what the costs are, and then you can put that money aside as well. So that way you actually can pay for it and you don't have to worry about them coming up with the cash. You can also, in New York State, you can prepay for funeral plans. What that means is that you can pick out everything you like and then you give money to the funeral parlor. They keep it in a trust account, it earns income and it grows. And when you actually die, they can go and take your plan and use it and use that money that's been held in trust with the state. If that's a direction you would like to go, that is a wonderful gift to give to your loved ones, because not only do they have to wonder about where the money's going to come from or what choices do they have to make, you've done all of it for them. So it's a huge gift and it's right off their plate. The last thing you should do is consult with an attorney. So once you have all of these items checked off your list, then go talk to a lawyer and see what they think you should do based on your specific situation with where you are. I've greatly appreciated the opportunity to talk to you today. I know this has run a little bit long, but I think it's really important that we just open up the conversation about wills and trusts and estates and what we can all do to prepare for our final ending. Thank you and have a wonderful day.